The Supreme Court petition for the Duncan v. Bonta lawsuit, which is our challenge to California's magazine ban, got an extension to July 18th. You want to make sure and get it right. Let's talk about it. Hey everybody, welcome back to the channel today. We're talking about SCOTUS again and the Duncan v. Bonta lawsuit. We were set to file this week. It looks like that's been extended a little bit. To talk us through that today, we have brought back the CRPA volunteer president. That, of course, is Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thank you for having me.
Yeah, absolutely. And guys, really quick, this is going to be a quick video. I will tell you, please like, share, and subscribe. The good work is going to get done. We want to push this out as far as possible. So please go ahead and like, share, and subscribe to these videos. It really helps. So Chuck, like I said, quick video. Just a little bit of an understanding here how all of this works. We were set to file for certiorari for the Supreme Court of the United States in our Duncan v. Bonta lawsuit. Guys, if you haven't been following along, Duncan v. Bonta is our challenge to Prop 63's magazine ban all the way back in 2016. This case has been through the Federal District Court, the Ninth Circuit en banc, all the way up to the Supreme Court, and then all the way back down again when Bruen came out, and then it went through that same process. Now we're back at the Supreme Court level. We were set to file for cert for it this week, but now that's been extended. So what's the reasoning here? Is this something that we've asked for? Is this something SCOTUS demanded? What's the purpose for the month extension?
No, we requested an extension because so much happened in the Supreme Court last week that could affect whether or not they take the Duncan case and grant our petition for writ of certiorari, that we need to include this in the brief. And it all happened like 2 days before our brief would have been due. So we requested an extension so we could put all that in there. Now we have to file our brief by July 18th. But the stuff that we want to include now is there was 3 dissents plus a statement from Kavanaugh in Snope. And those 3 dissents talked about how the lower courts were ignoring the Bruen precedent and they needed to take an AR-15 case and clarify the methodology, and AR-15s are the most common firearm used, and it doesn't have to just be used for self-defense. I mean, they knocked out a lot of the arguments that the states are trying to make, not just in the Duncan case, but in all the 2A cases across the country, where they try and limit what arms and conduct relating to arms are protected by the Second Amendment language. And then they try and come up with flimsy historical analogs, like a Bowie knife law justifies a assault weapon law. And that's all just a twist. And a lot of the Ninth Circuit judges are calling the other Ninth Circuit judges out for these shenanigans. But the point is, there was good language in the Snopes dissents. There was good language in Kavanaugh's statement. And there was good language in the Mexico versus Smith & Wesson case by Kagan, a unanimous 9-0 decision, acknowledging that AR-15s are the most commonly owned rifle used for lawful purposes, and pointing out that just because a gun may be particularly attractive to criminals, that doesn't make it justifiable to ban it from law-abiding citizens. Any gun can be attractive to law-abiding citizens, to criminals, but in fact, criminals' weapon of choice is the first one they can get their hands on. But that doesn't mean that it's not constitutionally protected when it's in common use for lawful purposes by law-abiding people who are using the guns for target shooting or self-defense or hunting or whatever. So that's great language that basically slaps down some of the arguments that the states have been making and that the state in the Duncan case is making. So we want to put some of that language from the Supreme Court front and center in our Duncan petition for certiorari. The other thing that makes Duncan attractive, and Duncan has a big spotlight on it now because it's been tried twice. There was a trial with evidence, with expert testimony. The record is packed with information. In a lot of cases, they've tried to just rely on common use and not even get into discovery, not even get into what the purpose of an AR-15 is, what value it has. And that just bit us in the butt in Illinois because in the Viramontes case versus Cook County, they had a local assault weapon ban. And the court there said, well, we're not going to strike down this law based on the record that you've given us. So the courts are saying that just proving a gun is in common use isn't enough. But the Duncan case has the record beyond common use. And also, interestingly, the Illinois case that is being briefed right now, the Illinois semi-auto ban has been tried twice and has a full record. So those two cases really have the spotlight on them. But Duncan is in front of the pack because the Illinois case hasn't. It's just being briefed and it's going to be argued in the Seventh Circuit, and then we'll have to wait for an opinion and then appeal that. Well, the Duncan decision is out, so it's at the front of the pack, and we just want to make sure that we maximize the chances of getting it and make use of any language from the Supreme Court that we can to increase the chances that they will take it.
So you've got a Supreme Court of the United States that's basically telling each other in dissents that a Second Amendment case needs to be taken. It looks like Duncan is at the front of the pack to be considered. It also seems to be the most ripe. So if you're going to get something in front of the Supreme Court, you definitely want to make sure it's right. So we ask for the extension. Make sure and get all the good language that you can possibly get in there. That extension, I believe you said, was July 18th, correct? So be sure, guys, to watch out. We'll certainly be doing a video as we file to kind of delve into that petition a little bit and then also kick off that process. Final question, Chuck. I guess the question that I always love asking, what's the timeline that you see on this? If the deadline for the petition is the 18th, it's already kind of getting late in the year. Is this what's the possibility that this gets either accepted or denied and potentially even heard? Is it going to be next year?
Yeah, it'll be next. I mean, the Supreme Court is about to go out of session in I think it's the last week of June. They don't come back into session until the first week in October. So this will definitely be in the 2025-26 session. We just saw what happened with Snopes. It was relisted 15 times. They didn't even decide not to take it until they had considered whether to take it 15 times. So you can get wrapped around the axle in the Supreme Court with these conferences where they're trying to decide to take a case and they don't make the decision, so they push it over to the next week and the next week and the next week. And so it's hard to say when they would make a decision about whether to grant cert in Duncan, but it will definitely be heard. If it gets granted, it'll be heard next year.
Well, definitely something to look forward to there. A lot of hope in that Duncan lawsuit. It has survived some courts that we didn't necessarily think it would survive in, but definitely something to look forward to with that SCOTUS petition. Chuck, thank you for coming on really quick to do this. I really appreciate it, and thank you for being with us today.
Hey, join and support the CRPA. We've got a lot of legal work to do. We give the CRPA our lowest nonprofit rates, but it still takes time to do these things right. And we just need the resources. We need volunteers. Join our chapters. I mean, there's a lot you can do to be involved in this historical development, be a part of history with CRPA.
Absolutely there is, and there's a lot you can do if you're out of state as well. The link is in the description below. As always, go ahead and join CRPA. Be a part of that fight. Be a part of moving the ball forward here at Ground Zero, where a lot of this bad legislation starts. So if we can stop it here, it's not going to spread to the rest of the country. Thanks again, guys, and we'll see you on the next one.